You're thinking of representing yourself in your medical malpractice matter. Why? Because you don't want to have to share your fee with your attorney. So now I have a question for you. When you reach out to the doctor's medical malpractice insurance company and the claims representative asks you, how much do you want to settle your case? Did you know that that answer that you give is going to affect you for the entire duration of your case? You want to know why? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now you've made the decision that you do not want to hire an attorney because you believe that you can go ahead and represent yourself, and you don't want to give up a fee, a percentage of anything you're actually able to recover to an attorney. All right, I understand that. So now instead you decide you're going to reach out to the doctor's insurance company. And when you get a hold of the claims representative, who now is focused on your particular claim, when the claims rep asks you, okay, Mr. Jones, how much do you need to settle this case? The answer that you give could destroy your entire case. The answer that you give could destroy your credibility. The answer that you give could cause the claims rep to actually laugh. And here's the question that I have for you before answering that particular question. How do you know the true value of your injury at that moment? Have you spoken with your treating doctors to determine whether or not you're going to need any additional care and treatment into the future? Have you spoken with any of your treating doctors or any medical experts to tell you exactly what you will be able to do and what you won't be able to do over the course of the years into the future? If you don't know that information, how can you give the claims representative an accurate demand of exactly how much you need in order to resolve your case? Another question I have for you is, how do you know what the value of your injuries are if you haven't done any research to determine what similar cases like yours have settled for in the particular venue where you might go ahead and file your lawsuit? If you haven't done that research, how do you really know what the injuries are worth? If you haven't done that legal research, how would you know what a jury has come back with in a similar case? And more importantly, after that matter was appealed, what the appellate court had to say about that particular verdict? Did they uphold that verdict? Did they increase the verdict? Did they reduce the verdict? Did they throw the verdict out? Did they force the injured party to go back and try the case all over again? If you don't know that information, how can you accurately go ahead and give a particular number to the claims rep? The reality is that you can't. You can't just pick a number out of thin air. Although, when you read in the newspaper that somebody's suing for millions and millions of dollars, that's exactly what it appears, as if somebody just plucked a number out of thin air. If this is the only amount you're going to take, and you say, I'll take this, if the insurance company is inclined to negotiate with you, guess what? They're going to come in with this amount. They're going to give you a lowball offer, hoping that at some point you can come to some sort of agreement or a compromise where you now say, yes, I will accept that. But from a negotiation standpoint, you never, ever want to make the demand the exact amount that you're willing to take. That's not good negotiation strategy at all. So, how do you really know what number to give to the insurance company? The problem is that unless you have a lot of experience handling these types of cases, you're going to be at a significant disadvantage without doing the legal research to know what other similar cases have settled for, and importantly, what this insurance company has settled similar cases for. You're going to be at a significant disadvantage. Without knowing what kind of verdicts these cases have generated and the appeals and the results that occurred on appeal, again, you're working at a significant disadvantage. And now if you make a wildly outrageous demand that is so incredible, the claims rep is likely to laugh and say, that's really funny. You go ahead and file your lawsuit, we'll see you at trial. And that's exactly what they'll do, which means that you will have lost all credibility with them because now they know that they're dealing with someone who is inexperienced, someone who doesn't understand the value of these injuries, the value of these disabilities. And when that occurs, now again, you're doing yourself and your family a significant disservice. So why do I share this quick information with you? I share it with you just to give you an inside look at what happens when you decide, hey, I don't want to go ahead and hire an attorney. I want to go ahead and do it my own. And you know what? You can try to do it on your own, but you're going to put yourself in a very bad position if you negotiate poorly or you don't have sufficient information to give an educated answer when the claims rep comes back and says, how much do you need to settle this case? Well, if you are considering bringing a lawsuit for your matter that happened here in New York, but have not yet done so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.